China's a good example. I'll give you an example of a problem that we encountered in China very recently. We were trying to litigate in a court in China, I can't remember which one. And we needed to get a witness statement notarized in Chinese, and then the notarized person, the notary needed to be translated in Chinese. That translation needed to be notarized, which of itself is pretty standard. So we did all that, and it was backwards and forwards, and eventually we thought we got the format right. We needed to get the whole thing formally declared as valid by the Chinese embassy in London. So we sent a courier down to 500-mile round trip down to London to get the thing notarized. And the Chinese embassy sent it back to us because we had the wrong colour ribbon attached to the document. The wrong colour ribbon. And you just become exasperated at that level of bureaucracy. And so for that reason, I wouldn't want to suffer that. I almost gave up the whole job, not just that case, the whole job. It's just, it's too much. So arbitration is a realistic alternative in China. Chinese businesses willingly submit to their own arbitration system. But we're not routinely offered that as an alternative, but realistically we should be pressing for it. We should be saying on behalf of our clients, certainly on high value commercial disputes, we want to arbitrate. We at least want to consider the possibility of arbitrating, provided we can get people to submit to it. Quite often you will. India. Another problem. I mean, I've chosen those two particular states for no other reason than the situations that we encountered very recently over the last couple of months are quite difficult, quite a challenge. In India, we were suing a debtor over a hospital debt, and we needed to in an Indian court. And so the Indian court came back and they said, right, well, you've got to prove that the hospital has the right to treat the patient. So you've got to go and find a charter that proves it. And so you go back to them and you say, right, now you've got to prove that the person who has produced this piece of information, the charter, has the right to do it. So how do you do that? Here's the charter, how do you prove that? Right, you've got to produce the board meeting where that person was appointed and given the right to make that assertion. I mean, how can you find that information? That's absolutely absurd. But that was a challenge that was set to us. I honestly don't think we rose to it. And the debt was never paid. But in India, they have based their arbitration laws on the United Nations model. And realistically, we should have been thinking about whether or not we wanted to use that process, an arbitration process, instead of going down the litigation route. Because litigation ultimately costs that hospital the possibility of collecting that money. And in future, I'm fairly certain that certainly there we will be exploring that possibility every time. Australia have quite a developed system of arbitration. Realistically, we should be looking at using that more and more. It's a very expedient and efficient method of dispute resolution in that country. Europe, it varies of course state by state, but in the UK, as in the United States, it's a default. You can't litigate in civil court unless you have first considered mediation or arbitration as an alternative. You have to at least consider it. And when it's referred, I'm jumping ahead of myself a bit, but when it is referred, in the UK, 67% of cases are resolved by means of mediation when they are actually referred in that direction. So it's not just a box to be ticked, it does actually work. Spain, Portugal, and Ireland. I would arbitrate every day of the week rather than litigating in those territories if I had the option. And I certainly would want to give my clients the option of litigating in those countries. And so on high-value commercial claims, I wouldn't think twice about it. Arbitrate every time if that was a possibility. Eastern Europe has adopted, because when they ceased to be Soviet, they were left with a bit of a vacuum in terms of their legal systems. And so it was a great opportunity for them to basically lift had a blank canvas. They took a whole series of other people's laws or model laws that had been created by the United Nations and simply incorporated them into their own systems. They used the best bits, really, of other people's legal systems, including the arbitration process. And so in those states, they actually have very good systems for arbitration. Now, whether or not the courts are able to enforce the judgments, the arbitrated judgments, that's another matter, because they still have quite a slow court system. But the arbitration system should be very good. They've also, I have to say, the United States has been very helpful, believe it or not, to the former Soviet states, because they're using former Supreme Court judges to help them build their legal systems. Slovenia, for example, is using the former Supreme Court judges, and they're actually helping to incorporate all of these new laws into their own legal systems. So the Middle East, that's an interesting one, because if you want to, their legal system is obviously born certainly out of a mixture of French and Sharia law. And so arbitration is conducted against that background. And so, for example, you have clauses, contractual clauses, which would appear in any standard Western contract, which are unenforceable under Sharia law, because they have clauses in them containing interest, for example, which might be deemed to be contrary to Sharia law. And so, for that reason, the arbitration processes have to take that into account, but they do. It's been driven by Bahrain. Bahrain have taken the lead on behalf of really all the Middle Eastern countries. And what they've done is they've built an arbitration process which takes account of all those things and is sympathetic to the various religious laws which exist. And so, theoretically, you should be able to arbitrate in those territories just as easily as you can arbitrate anywhere else. North America, I mentioned, very developed arbitration system in the USA. And according to, there's very little research actually that I've been able to find, but there was some in West Virginia, and Thomas McHugh, just to prove that I have actually looked this up, Thomas McHugh, who is a judge of the Supreme Court, says that arbitration is highly successful. He says, and 80 to 90% of all cases in West Virginia are settled without going to court, which is extraordinary when you think about it. And you think that the US courts are logjammed. Cases can drag on for a long period of time because they just are overworked. So being able to take all that overwork and put it through arbitration, I imagine it's made a significant difference. We tried to find, because we've got this in Canada, so I tried to find some research on the extent to which arbitration here has replaced standard litigation. And so we contacted the university here in Vancouver and got through to a professor, Andrew Newman, I think his name is. And he said, that's a very interesting question, but no research has been done. So, sorry about that, we don't know the answer. But at some unspecified point in time, we may find out whether it's been a success in Canada, but he's not able to help. And he is the professor of law at the universities. I'll have to take his word for it. Central America, not quite so good. It's really, to be honest with you, they've only just incorporated the laws which harmonise them in respect of basic civil litigation. And so getting the arbitration laws set up, I think really is more of a challenge. And if anybody from that territory can contradict me, please do so. But as I understand it, I don't think that anybody's going to be relying on arbitration as an alternative anytime soon. The same actually is true in South America. What actually happened in South America was extraordinary. The courts just didn't like the idea that the arbitrators were going to muscle in on their turf. And so what happened was the courts just intervened and said, we won't enforce that arbitration, or they just took it over. And so the whole work of the arbitrators just was completely undone by the courts. And so again, South America, no time soon anyway. So In conclusion, I'm pleased to say that we are at the conclusion stage. What the commercial community demand of us, the suppliers, is cheap and speedy dispute resolution. I would, a couple of years ago, have said cheap and speedy litigation, but that's not what it is. It's dispute resolution. And what we need to be providing to them is exactly that. The quickest, easiest and cheapest way of recovering the money for the client. And what we're not doing, generally as an industry, is we're not looking at arbitration as part of that process. We're not building it into our own processes. We've all got it as part of our domestic process. We have to, because in the UK, for example, you can't actually litigate in a civil court unless you actually consider mediation. So it's there, but it's not there when we're litigating in China, it's not there when we're litigating in India, and it's not there for most other places. And what we need to do is we need to put it in place so it's there as an option for the client to consider. Is it cheaper? Is it quicker? Is it more likely to yield fair results? Well, in all likelihood, yes. And so what we should be doing is offering exactly that. Kevin said earlier, I think, we innovate or we die. And unless we take these opportunities to provide a better service to our clients and to make sure that the service that we are providing is the best, then our competitors will thrive and we will die. Somebody quoted Churchill earlier. Well, he said, you need to improve to change, but to attain perfection, you need to change often. Now, it's not a witty one-liner, but it's right. You need to change continuously. And this is one small change that we should be making that makes what we do an awful lot more efficient. I'm available for questions at the end.